The rule on examination of child witness. So this rule can not only be found in our rules of court, but also can be found in Administrative Matter number 007-04-SC. For other principles relative to this law, you can cross-refer to other laws, such as that in RA 7610, or the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. This rule, as the title speaks of itself, governs the procedure whenever the witness is a child. So when is a witness considered as a child witness? So a child witness is a person who at the time of giving of his or her testimony is below 18 years of age. So that is the general rule. So when a person is below 18 years of age, he is considered as a child witness. But there are instances that a witness, even if he or she is above 18 years of age, is still considered as a child witness. So that is in child abuse cases, whereby the person who gives his or her testimony is above 18 years of age, who is unable to protect himself or herself from abuses, cruelty, discrimination, exploitation due to his physical or mental disability or condition. Just like any other ordinary witnesses, a child witness must be able to perceive, and in perceiving can make known their perception to others. So, in the rule on examination of child witness, a child witness is presumed qualified to testify in court, but this presumption is rebuttable. So, the court can motu proprio or on motion of a party move for competency examination when it finds that there is substantial doubt as to the ability of the child to testify in court. That is, his or her ability to remember, to perceive, or to distinguish between the truth and falsehood, or to appreciate his or her duty to tell the truth in court. Of course, this includes the ability of the child to communicate his or her testimony. So in competency examination, the one who assesses the ability of the child to testify in court is the judge. It is the judge who asks the questions to the child. The counsels or the parties may ask questions, but their questions must be coursed through to the judge. So one need not worry if the court motu proprio conducts the competency examination. How about if the party moves for the conduct of the competency examination? Well, the party counsel must show proof of necessity to conduct said examination. And this presumption, of course, as what I have said earlier, the presumption that the child witness is qualified to testify in court is rebuttable, and the one who rebuts this presumption has the burden of proof to prove that said child is not qualified to testify in court. The court has a continuing duty to assess or determine the competency of the child during the course of the proceedings. So, just like any other witnesses also, the testimony of the child witness must be under oath or affirmation. When the child gives his or her testimony in court, the best interest of the child is of utmost priority. So as a rule, when the child testifies in court, he or she will sit in the witness stand. Those who are not interested in the proceedings shall be asked to go outside of the courtroom. There are also instances whereby even those persons who have interest on the case are asked to be excluded in the court proceedings. So these are in criminal cases such as child abuse cases. The accused need not be worried since the counsels or his counsel will still be present to protect his right, especially his right to cross-examine the witness. Considering again the best interest of the child, while waiting for their case to be called, a child witness need not be waiting inside the courtroom. They have their own rooms where they could wait. So here in Cagayan de Oro City, child witnesses are asked to wait in a separate room. So in the Court Social Welfare Office, they are asked to wait there while their case are not yet called. So this is to eliminate any fear of the child to testify in court. Going now to the point where the child has to testify in court. So the child, as a rule, has to give his or her testimony inside the courtroom. So the public may be excluded if needed. Considering the best interest of the child, that the child witness examination shall be conducted inside the chambers of the judge or with the use of a live link television. That is, the child will be placed in a separate room, and then a live link television shall be installed inside the courtroom. So while the child is in there, inside a separate room, the counsels, the court personnel, and the judge shall be in the courtroom. So the questions will be asked inside the courtroom, but the child will have to answer it in the separate room. In ordinary witnesses, whenever a person is presented in court by a counsel, during direct examinations, leading questions are not allowed. But in child witnesses, leading questions are allowed and not objected thereto. How about on other objectionable questions? Well, a counsel can still object to questions, but he has to make it in a manner so as not to cause fear or confusion to the child. Corroboration shall not be required, especially if it is found that the child witness is credible. So that would be sufficient for to support a finding of fact, judgment, or conclusion, but it is still subject to the standard of proof required in criminal or non-criminal cases. It is also important to note the sexual abuse shield rule under the rules on examination of child witnesses. So under the sexual abuse shield rule, evidence is admissible if the evidence is offered to prove that the child is involved in other sexual behavior, or if the evidence is offered to prove the sexual predisposition of the alleged victim of child abuse. So the sexual abuse shield rule is subject to exceptions. So evidence offered to prove that the child witness or the victim of child abuse is involved in other sexual behavior. So evidence offered to prove that there could be another person who could be the source of the semen, who could be the cause of the injury, or other physical evidence can be admissible as evidence, being an exception to the sexual abuse shield rule. Another thing which is important under the rules on examination of child witness is there is a rule which is an exception to the hearsay rule. So as a rule in our rules on evidence, hearsay is objectionable, that is, it is inadmissible as evidence because a witness must have personal knowledge as to the testimonies that he or she gives in court. But under the rules on examination of child witness, statements made by a child describing an act of child abuse or an attempt of act of child abuse may be admissible as evidence, but this is subject to conditions. Before such a statement may be admitted as evidence, the proponent must make known to the adverse party's intention to do so, as well as its particulars, so as to give the adverse party an opportunity to object. So by the time that such hearsay statement will be presented in court, the court may, upon motion of the adverse party, require the presence of the child to give opportunity to the adverse party to cross-examine the child. When the child is unavailable, such fact shall be proven by the proponent. So that is the gist of the rules on the examination of child witness. So what you have to bear in mind is, again, the best interest of the child. That is utmost priority whenever a child witness is presented in court.